The Senate will come to order. The Senate will come to order. The Senate will come back to order. Will the Secretary read the caption to Senate Bill 104?
Senate Bill 104 by Senator Payne of the 54th and others, a bill entitled Enactment Code Section 3139-4 of the OCGA, relating to persons authorized to issue order not to resuscitate so as to revise parental requirement for consent and for other purposes. Mr. President, the Senate Committee on Judiciary offers the following substitute to Senate Bill 104, a bill entitled Enactment Chapter 39 of Title 31 of the OCGA, relating to cardiopulmonary resuscitation so as to revise parental requirement for consent and for other purposes. Amendment 1 by Senator Huffstetler of the 52nd offers the following amendment. Amendment 1 to amend the substitute to Senate Bill 104 by, on line 11, strike child and replace with minor. Mr. President, that concludes the order.
The Chair would like to recognize the Senator from the 54th to speak to Senate Bill 104.
Thank you, Mr. President. I'm honored to bring you Senate Bill 104. Senate Bill 104 has no intent to change the current law, but it was literally a two-year effort now for us to only serve to clarify the language within the law in regard to a do not resuscitate order placed on a minor child and assures that a DNR order will not be placed on a minor child without a parental knowledge and consent, which is the current law in Georgia. Working with Family Policy Alliance and the Georgia Hospital Association, we've came up with the draft that you have before you. Last year, the Senate passed our efforts to clarify this code section of the law by unanimous consent, and I ask for your vote for Senate Bill 104. There is a senator from the 52nd has an amendment. There's a friendly amendment, and I will ask you to vote for that as well. If there's no question, Mr. President, I will yield the well.
Chair recognizes the Senator from the 38th for a question.
Thank you, Mr. President. Will the Senator yield?
Yes, ma'am, I will.
On line, I believe it is 17. No, it's 18. 17. The last word on that line is oral or written consent.
Yes,
I'm
ma'am.
a little concerned about oral in this kind of
Because the
situation.
original code section, if you look in there, it says, what it was saying is any parent may consent orally or in writing. And so we're trying to stay close to the same language without changing the language, but really just we're concerned with the may, that a parent may consent. And so we were to make sure that the parent, and everyone has clear understanding that a parent must consent before a doctor can issue a DNR order.
Yeah, will you further yield? I'm just concerned about oral, at getting oral consent versus, my thought is it should be, that it should be written, that they should be signing off on it. That it's important in this type of situation to me that you've got that hard, written consent versus just oral. That's the only thing I'm concerned about is the oral part of it.
Yes, Senator. Like I said, I did not want to take the attempt to change the law right now as the way it is, but just make sure that we clarified the law and the language so that we were getting rid of the may, so to make sure that people understood that it is the law in Georgia that you have to have consent of the parent or guardian before you can issue a DNR order.
Thank you.
You have no more questions.
I ask for your favorable consent of Senate Bill 104. Thank you very much.
Chair would like to recognize the senator from the 52nd to speak to his amendment.
Thank you, Mr. President. This amendment would strike the word child, and I'm not striking a child if anybody's getting that impression. Don't read it wrong, and replace it with the word minor. The reason is minor was originally in this and it got changed, and minor is defined in the code, and so we need to go back to that. And no, I'm not a lawyer, but I've been hanging out with a few of them. No questions, I'll yield the well.
You have no questions. Would any of the senators wish to speak to the bill or the amendment? All right, we'll take up amendment number 1 first. The question is on the adoption of the amendment. Is there objection to adoption of the amendment? Hearing none, the floor amendment is adopted. The question is now on the adoption of the committee substitute as amended. Is there objection to adoption of the committee substitute as amended? Hearing none, the committee substitute is adopted as amended. Shall the main question, is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 46, the nays are 0. This bill having received the requisite constitutional majority is therefore passed by substitute. Secretary, please read the caption to Senate Bill 122.
Senate Bill 122 by Senator Kennedy of the 18th and others, a bill entitled Enactment of Article 22 of Chapter 1 of Title 10 of the OCGA relating to motor vehicle franchise practices so as to provide for protection of certain consumer data in motor vehicle sales or lease transactions and for other purposes. Mr. President, Senate Committee on Regulated Industries and Utilities offers the following substitute to Senate Bill 122, a bill to be titled Enactment Article 2 of Chapter 1 of Title 10 of the OCGA relating to motor vehicle franchise practices so as to provide for protection of certain consumer data in motor vehicle sales or lease transactions, to provide for definitions, to impose certain requirements and restrictions on the use and disclosure of consumer data by franchisers, manufacturers, distributors, and third parties, to provide for indemnification of motor vehicle dealers for certain claims and damages related to disclosure of consumer data, to change certain provisions for purposes of conformity, to change certain provisions relating to uniform warranty reimbursement policies amongst dealers, and for other purposes. Amendment 1 by Senator Kennedy of the 18th offers the following amendment. Amend the Senate Committee on Regulated Industries and Utilities substitute Senate Bill 122 by inserting the following containing on line 134 by inserting the same following of on line 143 and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 18th to speak to the measure.
Thank you, Mr. President, and good afternoon, colleagues. I bring to you Senate Bill 122. You may have known this already, but I did not, excuse me, before working on this bill, that the relationship between the automobile manufacturers and the Automobile Dealers Association is not just a subject of their agreement or some sort of contract, but rather is the subject of Georgia franchise law. Franchise laws got put into place several decades ago because of the recognition of the imbalance between the manufacturer's position and the dealer's position. So legislatures have stepped in across the states, and so from time to time, those franchise laws need to be tweaked to get the balance back right as they should be. We're at that point now where we need to modify them, and what I have before you in Senate Bill 122 does just that. What I'm very pleased to tell you is that all the stakeholders came together and they have agreed to the terms of the franchise laws that will govern their relationship between the automobile dealers and the manufacturers. I want to applaud all those stakeholders, the manufacturers and all the dealers, for coming together, excuse me, as well as their representative association leaders in coming together. Why do I tell you that? I tell you that because this bill, unlike most of the ones that we deal with, which have great impact or can have great impact on the citizens of Georgia, this law that we would pass really mainly impacts just those two stakeholders, automobile manufacturers and automobile dealers. But let me just touch just for a moment and tell you some of the topics that are touched on before in the legislation before you. One relates to the data protection of consumers' information. Dealers wanted to make sure that information that's obtained when a consumer comes in to either get a loan or buy a car, that information is protected as it's sometimes transmitted up to the manufacturer. The other topics included incentive programs, audits, factory images, meaning the showrooms, the terms of things like that, performance criteria, and warranty surcharges. All of those topics are addressed in the bill before you in the various 7 sections in the bill before you. I'm pleased to tell you it came out of a subcommittee. I appreciate the Regulated Industries Chair creating that subcommittee. It came out of the Regulated Industries Committee, I think unanimous as well, and so I would encourage you to vote for it. There is one amendment, and the reason the amendment is there, that reflects the final changes that these two stakeholders came to in their continued negotiations even after we had voted the bill out of Regulated Industries. So with that, Mr. President, I'm happy to answer any questions or explain anything about the bill.
You've done such a great job, you have no questions.
Okay, thank you, Mr. President. I urge you to vote yes. Thank you.
Would any other senator wish to speak for the bill or the amendment? He's already yielded the well. All right. We'll take up amendment number 1 to start with. The question is on the adoption of amendment number 1. Is there objection to adoption of the amendment? Hearing none, the floor amendment is adopted. The question now is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Chair hears none. The committee substitute is adopted as amended. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. State your inquiry.
I wish to be excused from voting based on Rule 5-1.1.8D on this legislation.
The secretary has ruled that it's too late to make that excuse, to grab that excuse. The vote's already on the board.
That's what I was trying to do earlier.
On the passage of the bill, the yeas are 50, the nays are 0. This bill having received the requisite constitutional majority is therefore passed by substitute. Mr. Secretary, please read the caption of Senate Bill 29.
Senate Bill 29 by Senator Jones the 22nd and others. A bill will be titled Enactment Code Section 3692(1) of the OCGA relating to definitions regarding waiver of immunity for motor vehicle claims, so as to revise the definition to clarify that a sheriff, deputy sheriff, or other agent, servant, or employee of a sheriff's office shall be included in such waiver for purposes of the waiver of sovereign immunity for local government motor vehicle claims and for other purposes. Mr. President, the Senate Committee on Special Judiciary offers the following substitute to Senate Bill 29. A bill will be titled Enactment Code Section 3692(1) of the OCGA relating to definitions regarding waiver of immunity for motor vehicle claims, so as to revise definition to clarify that a sheriff's office shall be considered a local government entity, that a sheriff, deputy sheriff, or other agent, servant, or employee of a sheriff's office shall be included in such a waiver for purposes of the waiver of sovereign immunity for local government motor vehicle claims and for other purposes. Amendment 1 by Senator Parent of the 42nd offers the following amendment. Amend the Senate Committee substitute to Senate Bill 29 by deleting lines 13 through 16 and renumbering the subsequent paragraph accordingly. Amendment number 2 by Senator Parent of the 42nd and others offers the following amendment. Amend the Senate Committee substitute to Senate Bill 29 by striking line 13 the words 3 and by striking lines 14 through 16 and renumbering accordingly. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 22nd to speak to Senate Bill 29.
Thank you, Mr. President. This is a cleanup bill. Everyone's heard the old adage about the fact that you can't sue the state, but there are certain times we actually allow you to do that, and that's when we waive immunity. And one of those times is we waive immunity for car accidents when a deputy or a government employee is driving a government car and in the line of duty. And so what we've done is we said that the proper party to sue in that particular instance is not the individual employee, but the actual office. And so what this bill does, because it clarifies, because there was a question about whether deputies were included into this definition, and what has been happening is sheriff's officers, the individual deputies, have been getting sued personally, and that, of course, is not the intent of our bill. That's not in the intent of our waiver. So what this bill does, it clarifies that sheriff's deputies, the individual deputies, are local government officials, and so therefore they will not be sued personally, and the proper entity will be the sheriff office. There is a friendly amendment. It is actually Amendment 2, which will be going for. I believe the author is going to withdraw Amendment 1. And what Amendment 2 does is remove sheriff's offices from the definition of local government entity. The sheriff offices were concerned that that might cause some confusion because they are constitutional offices, the sheriff office itself. So it's actually going to be Amendment 2. I believe the author is going to withdraw Amendment 1, but they are friendly amendments. And with that, I'll take any questions, Mr. President, if there are any.
Chair recognizes the senator from the 56th for a question.
Thank you, Mr. President. Senator, will you yield?
Yes.
On the amendment, I realize this is not your amendment, but you support it. Has the Georgia Sheriff's Association been in contact and approved this amendment?
Yes, and it actually was their idea to make sure this amendment went through.
Thank you.
Yes.
You have no additional questions.
Thank you, Mr. President.
Chair would like to recognize the author of both amendments, senator from the 42nd.
Thank you, Mr. President. I believe the author of the bill already adequately explained the reason for the amendment, and I'm happy to answer any additional questions. Are there any about the amendments, Mr. President?
Sorry, I couldn't hear you. Say that one more time, Senator.
Was just wondering if there were any additional questions about the amendments.
You have no questions.
So when I return to my seat, I'd like to ask for unanimous consent to withdraw amendment number 1.
You have that right. Chair recognizes the senator from the 42nd.
I'd like to ask for unanimous consent to withdraw amendment number 1.
Senator from the 42nd has asked for unanimous consent to withdraw amendment number 1. Is there objection? Hearing no objection, amendment number 1 is withdrawn. We'll now take up amendment 2. Would any other senators wish to speak to the bill or the amendment? All right, we'll take up amendment number 2. The question is on the adoption of amendment number 2. Is there objection to the adoption of the amendment? Hearing none, the floor amendment is adopted. The question is now on the adoption of the committee substitute as amended. Is there objection to adoption of the committee substitute as amended? Chair hears none, and the committee substitute is adopted as amended. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 1. This bill having received the requisite constitutional majority is therefore passed by substitute. Mr. Secretary, can you read the caption of Senate Bill 135?
Senate Bill 135 by Senator Walker the 20th and others, the bill we titled enactment in Chapter 9 of Title 34 of the OCGA relating to workers' compensation, so as to change certain provisions related to workers' compensation administration and benefits, to change certain provisions relating to the eligibility for appointment as administrative law judge emeritus of the State Board of Workers' Compensation, and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 20th to speak to Senate Bill 135.
Thank you, Mr. President. Good afternoon, colleagues. I bring to you this afternoon the Workers' Comp Annual Update Bill. Workers' Comp is, as you know, kind of a self-contained system that we have with its own court and its premiums paid into it. Support the system, business owners pay into it, and it takes care of injured employees and relieves the businesses from the threat of lawsuit from an injured employee, and we have to keep it up to date, so that's what this bill does. It does a few things. First, it raises the weekly maximum benefit from $575 to $675. It raises the partial weekly benefit from $383 to $450. And it raises the death benefit in the event an employee is killed on the job from $230,000 to $270,000. These benefits are still based on 2/3 of the actual wages of the employee. So if an employee is making $600 a week, the increase is not going to impact what that employee would get as far as benefits. They would continue to get the $400 a week. So it's 2/3 of their current pay with a maximum of this weekly benefit of $675. So whichever one is higher. This bill also addresses kind of a loophole in the system that allows Judge Emeritus to get excess compensation that was not intended. So any effective basically June 30, 2019, it would eliminate any future Judge Emeritus status. If there are any questions, I'll be happy to try to answer them. Ask for your favorable vote on this bill. If there are no questions, I will yield the well.
Chair recognizes the senator from the 36th for a question.
Thank you, Mr. President. The gentleman, Senator Yield.
Yes, ma'am, I certainly do. Hey.
Hey, thank you. I support this bill. I think it's the right thing to do, and I appreciate your explanation. I mean, we're still the second lowest comp rate in the entire country, so we should understand that as we support your bill, that this is moving to begin to close that gap and do the right thing for injured workers. And we haven't increased benefits, I think, in 3 years now. Historically, we would do it every 2 years, and we, as you know, this comes from all the stakeholders get together and make the recommendation. Isn't that true for what needs to be addressed in the workers' comp?
Yes, Senator,
system?
those are all very good points, and I appreciate you raising them. We have an advisory council that works closely with the Work Comp Board, and the advisory council includes members from business and industry and attorneys, and they come together with a recommendation for this. And even with the increase of $100, raising the cap $100 a week, we still will be 49th in the country as far as our maximum weekly benefit. So it's still a very conservative system that is very business friendly.
Yeah, thank you for that. And they're just correct me, but I don't believe there are any amendments that are being offered. Is that right?
I'm not aware of any amendments.
Okay, thank you, because I'm happy to support the bill without amendments. Thank you.
Thank you, Senator.
Chair recognizes the senator from the 32nd for a question.
Senator, would you yield?
Yes, ma'am.
Senator, isn't it true that I used to serve on the advisory council for the Workers' Comp Board for about 10 years?
I wasn't aware of that, but that's neat to know. Yeah.
And isn't it true that the advisory council is a mechanism to try to get all parties to agree on legislation that comes to this body?
Yes, ma'am. We get
And
all
in
the
fact, that
stakeholders at the table. Yes, ma'am.
And in fact, that they did agree to bring this bill forward and that all parties supported it?
That's correct. Yes, ma'am.
Thank you.
Thank you, Doctor.
You have no additional questions.
Thank you. I ask for a yes vote.
Does any other senator wish to speak for or against the bill? The chair hears none, and the previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, will you read the caption of Senate Bill 77?
Senate Bill 77 by Senator Moles, the 53rd, and others, a bill entitled Enactment Chapter 3 of Title 50 of the OCGA, relating to state flags, seal, and other symbols so as to provide additional protections for government statues, monuments, plaques, banners, and other commemorative symbols, to provide for definitions and for other purposes. Mr. President, Senate Committee on Government Oversight offers the following substitute to Senate Bill 77, a bill be titled Enactment Chapter 3 of Title 50 of the OCGA, relating to state flags, seal, and other symbols so as to provide additional protections for government statues, monuments, plaques, banners, and other commemorative symbols, and for other purposes. Amendment 1 by Senator Jones of the 10th and others offers the following amendment. Amend the Senate Committee substitute to Senate Bill 77 by adding civil rights after the word civil on line 21. Amendment 2 by Senator Parent of the 42nd and others offers the following amendment. Amend the Senate Committee substitute on government oversight substitute to Senate Bill 77 by striking line 43 and inserting in lieu thereof the following. Measures for the preservation, protection, and interpretation of such and for other purposes. Amendment 3 by Senator Parent of the 42nd and others offers the following amendment. Amend the Senate Committee on Government Oversight substitute to Senate Bill 77 by striking from line 1 through the end and inserting in lieu thereof the following. To amend Article 1 of Chapter 3, Title 50 of the OCGA relating to state and other flags and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 53rd to speak to Senate Bill 77.
Thank you, Mr. President. Members of the Senate, I bring to you an easy bill. Well, one that has created great debate in our country. And I'm proud to be up here to talk about it. This is about history again, in my opinion, and how our culture has become such a great society from the diversity we have, the good, the bad, and the indifference. I think that makes us who we are. Senate Bill 77 creates law. The current law that's already in existence protects military monuments and memorials from removal or destruction. The reason I brought this to us is several recent years ago in my hometown cemetery, there were some monuments and headstones that were destroyed. And, you know, I think it was probably some kids that were not behaving and may have not listened to their mom and their daddy and their bringing up and their rearing, and maybe needed their rears tanned. But we don't know who they were. So that kind of brought this to my attention. Then we see all the discourse around America about people not handling, I think, their opposition appropriately. Senate Bill 77 creates additional protections, not for any particular monument, not for any era monument, not for any mission statement, not for any special purpose, but for all monuments, all of them. This protects them in the public sector, and this protects them in the private sector. And what we've added to the description are some that, you know, just for preference purpose, just to make sure you understand, would be the monuments and memorials that are dedicated to religion, civil, political, social, cultural events, and a series of events. And Amendment 1 with my friend, the senator from the 10th, we're going to add civil rights in that caption too. Senate Bill 77 would permit removing or relocating of monuments when they're construction or renovation, but even with that is to be in a prominent position, not hidden behind a group of trees or covered with a blanket or so forth. But this bill allows our history to be preserved. It's that simple. Again, history that one may think is not appropriate, or maybe one that thinks it is appropriate. But in this case, this bill simply protects all monuments, all memorials, all honoraries. And of course, if someone is caught trying to desecrate a monument, they have to pay whatever the monument costs, plus penalty and fine. It would be equaled up to 3 times the cost of the monument. We will continue to add the collection of monuments and memorials and honoraries. Instead of take them away, let's add additional ones. Monuments erected around the states were erected to preserve the memories of those who gave their lives in a community. Whatever flag it's marked under, this is all about the memorial of people who gave their lives for whatever reason, in many cases, especially when it's veteran-related. Just as the General Assembly enacted legislation to erect a statue of Dr. King on the northeast quadrant of the Capitol in 2017, and also in the very near future, thank you to the Senator, the Chairman of the from the 15th, we'll be adding a Zell Miller statue hopefully in the near future. So let's add additional statues and memorials and honoraries to preserve history for this moment, for the next moment. And who knows, in 100 years, those may be offensive to somebody. We don't know what the future holds for any of us. When we get up in the morning, our feet hit the floor, and we get breath in our lungs, and we praise God that we're alive, that's the only thing that we can wake up to. We never know the future. We never know what's going to happen in 100 years if somebody said, oh, that's offensive to me. So let's preserve our history. That's all this bill is asking. Let's preserve our history, good, bad, or indifference. It has made us who we are in this state and this great country today. The indifference that we have is why we're the greatest country in the world. So let's take a deep breath and let's preserve our history. If somebody wants to tear it up, to take it down, let's penalize them for it. We don't need that to happen. Mr. President, there are a lot of people that want to talk about this issue, have their face time, and that's very commendable of them. And I could stand here and be battered with a bunch of questions, and I'd be honored to do that for my friends out there. But I would suggest let's everybody have their time in the well, and I'll come back and close. If there are any questions, I'll ask them. I'll be glad to answer them then. So, Mr. President, I yield the well.
Thank you, Senator. Chair would like to recognize the senator from the 29th. To speak to the bill.
Thank you, Mr. President. I rise today, Senators, to speak on behalf of this legislation. I want to tell you about a young man from Big Creek, Alabama, outside of Dothan. His name was Alto Cobb. And Alto Cobb, who honored his family and his family's lineage, volunteered and joined the United States Army at 20 years old. And at the age of 23, while serving under General Blackjack, in 1918, he drew his last breath in France because he was fighting for his country, fighting for his family in Dothan, Alabama, and fighting for my family because Alto Cobb was my uncle. If you walk into my house, there's a beautiful oval frame above our farm table, and in it is my Uncle Alto. And next to it is a certificate announcing his death that my great-grandmother received when her son was killed fighting for this country. He fought in World War I, and now today our U.S. Supreme Court is narrowly listening to a case brought by a group of people that want to take down the Peace Cross in Maryland. It's a cross that bears the names of 49 men who died along with my uncle, fighting for freedom, not only for freedom of Americans, but freedom for everybody in the world. And there's a case in the U.S. Supreme Court because of groups of citizens that want to hook a chain to some pink marble in Maryland and drag it down because they're offended by it. There's many things that I see that I'm offended by, statues, other memorials. I don't stop and read them unless I want to be a little more informed. But a lot of things. There's museums that tout serial killers and everybody else in this country, and I choose not to go in there because I'm offended by it. But what we cannot do is bleach the history of our country. What we have to do is learn from our mistakes in the past and our successes in the past. We've learned from this morning we have problems in education. We have problems in health care. We have problems with children going to bed hungry in Georgia and we have people worried about tearing down memorials to things that happened 100 years ago. Well, I pity the person that tries to tear down a memorial to my Uncle Alto, because they'll need to go past me to get to there. Thank you, Mr. President, and I yield the well.
Thank you, Senator. Chair recognizes the senator from the 41st, the minority leader, to speak to the measure.
Thank you, Mr. President. I'm afraid the only way I get my question answered is to come up here and maybe direct it to the author, and when he comes close, he'll give it to you, because didn't get a chance to get my questions answered. One question I was going to ask the last two speakers was, what about flags? This bill changes the definition of monument to include flags. So does that mean every time we post a flag outside the center at Stone Mountain Park, it becomes, by definition, a monument and can no longer be taken down or moved? Even though the flag is not a bronze or rock permanent structure, it will degrade in weather. I think that that change, making flags a definitional change to become a monument, is problematic for a number of reasons. And that's what this bill does. Number two, I'm worried about the fact that we're taking out interpretation. My friend, former House member and CEO of DeKalb County, Michael Thurman, served on the governor, appointed him not too long ago, he's now off, but onto the Stone Mountain Memorial Association board. And he did that because he knew Mr. Thurman was a reasoned, good person with a degree and background in history, and was a not a professional historian, but an amateur historian. He has since brought up things like a bridge in Stone Mountain Park that was built by an African American, and other historical issues in the park that are something that the African American community can be proud of. But one thing that he had suggested and talked about, and I think would be interesting, would be around the mountain to put a museum with historical content about the historical nature and effects of the Civil War, of slavery and other things. To put that at the base of the mountain, my question to the author was, by not allowing an interpretation of a monument, would that be precluded from that? Exactly how far does that interpreting a monument go? And so, you know, I have problems with that. But most of all, I have a problem with us, and I understand the concerns. I do not think we should remove the Stone Mountain Park's in my district. I don't think we should move the statues. I do feel we should put a museum at the base, putting in the historical content, the effects of the Civil War and slavery, even a Holocaust-style museum there on the effects of slavery on so many people in Georgia and in this country. But one thing a couple people said is we shouldn't change anything. We put something up, we shouldn't change it. It should be there forever. Listen, a society evolves and it changes. It has greater understanding from a historical perspective of what's good and what's bad. And you know, there are times and things that are bad that maybe we build a monument to, and we should be able to reflect on that. And if the society, the majority of people think it's a bad thing, then it should be allowed to be removed or changed. This bill takes that away. There's an amendment from the senator from the 42nd that allows local communities to make that decision. And she also has an amendment, I believe, that would allow the interpretation, again, by local community people to be able to be presented. So I hope you will sincerely consider those amendments. Otherwise, I do have concerns for the bill. Again, we should allow communities and societies to evolve and develop and change their mind. So I'll yield the well if there's no questions.
You have a question. Chair recognizes the senator from the 35th.
Thank you, Mr. President. Mr. Leader,
Yes.
will his bill, I was going to ask the author, but he didn't take the question. But 3 years ago, we passed legislation, and it was signed into law to put a photograph of Coretta Scott King on the second floor, and it's never been done. But would that have anything to do with her picture too, and maybe funding it, or whatever reason why they didn't put it up there?
I can't see any direct correlation between this bill and that fact, Senator. But
just trying.
The chairman of rules maybe could help you with that.
Thank you
sometime
very
in the future.
much. Thank you.
You have no more questions.
Thank you.
Chair recognizes the senator from the 10th to speak to amendment number 1. Chair recognizes the senator from the 10th to speak to amendment number 1.
Thank you, Mr. President, and it's about ALPA. And let me thank my colleague from the 53rd, the Rules Chair, who saw fit to include the language on here on civil rights. And I offer up Amendment 1 as a to the committee substitute to Senate Bill 77. If there's any questions, I'll yield for questions. If not, I yield well.
You have a question. The chair recognizes the senator from the 53rd.
Thank you, Mr. President. Senator Yule.
Absolutely.
I want to thank you for bringing that amendment to us and to me to let me assign, because I think that's important we make that statement, if nothing else. So I just want to thank you. Isn't it true that I want to thank you?
It is true, Mr. Chairman, our Rules Chair, and thank you for the detente in this chamber.
You have no more questions.
Thank you. I yield well. Thank you, Mr. President.
Chair would like to recognize the senator from the 42nd to speak to amendments number 2 and 3.
Thank you, Mr. President. I'm really pleased to have the opportunity to talk about this issue because it's one that folks in my district and in my community have been talking about for a couple of years now. And I'm excited to tell you all about it. So legislation that I had that was also heard by the Government Oversight Committee, and you will see this legislation in Amendment 3, would permit local governments to remove or change these monuments upon a duly adopted resolution of the public entity owning the monument or plaque. And the reason that I offered this bill is because in the middle of my district, in the city square of Decatur, which is the county seat for DeKalb County, there's a really, really tall 30-foot obelisk. And about 18 months ago, folks sort of really zeroed in and wanted to know what is the story behind this obelisk. And this obelisk has some questionable language that runs around the bottom of it. It talks about how the Confederate war dead were of a covenant-keeping race, and it extols their virtues and also the alleged virtues of the slaveholding South. And this monument was not erected right after the war to the Civil War to honor the fallen Confederate soldiers. It instead was erected 4 decades later on the heels of the Atlanta race riots and placed, like many that were erected during that era, right in front of the courthouse to send the message of white supremacy to all the residents of DeKalb County. DeKalb County is the owner of this monument. This debate is about what we permit local communities to place in a place of importance and revelry within our communities. You know, we've got hundreds of Confederate monuments around the state. And to the Rules Chairman's point, you know, maybe they don't all need to go, but I don't think they all need to stay either. There isn't an opportunity for DeKalb County to add to this monument, as a matter of fact, because while DeKalb County owns the monument and the land that it sits on, all of the square surrounding it is owned by the city of Decatur. They don't have the option to add to it. A lot of residents in the DeKalb and Decatur community dug into the story of this obelisk, and they said, you know, this thing is the most prominent thing that we've got in the middle of the county seat in Decatur. And that's not really what we want to honor. We can think of a lot of other things that we would rather honor when we're going to eat and dine. And DeKalb County undertook an investigation, decided that they would, under the current state law that we have, which as many of you know, is a compromise from when the flag was changed some 18 years ago. The state flag was changed and these protections for the other monuments and Confederate symbols was put into place. DeKalb County decided, all right, under this law, we are permitted to relocate this monument as long as we're putting it in another public place where people can go see it. So they passed a resolution that that's what they were going to do. And then they went through 2 RFP proposals, thinking that they were going to get proposals from groups that wanted to relocate it elsewhere. For example, the Decatur Cemetery is nearby that also has graves for Confederate war dead. And there were many among the groups agitating to have this obelisk removed from the middle of the square in front of the courthouse, that the cemetery would be a good spot for it. Well, what happened? Not one group offered to take the monument. Even the county could put it down on some other land they own. We've heard suggestions that they could put it down by the dump, as a matter of fact, that we could have it down by the sanitation yards. Well, the sanitation workers don't want it. So there it is. It's stuck. So the county is now undertaking to erect, just next to it, right by it, a sort of explanatory plaque that gives more of the history of this monument, because right now there's no history at all. It just is this really tall 30-foot obelisk. And what it really is about is I can understand if folks in other communities that they feel that a monument to the Confederacy or the Confederate war dead is something of importance to their community that they want to revere in the middle of their community. And that's okay with me. As I said, I don't think they all need to go, but they definitely don't all need to stay. And for the diverse folks in my community who eat and shop and dine and work and make up our community, when they see that, they view it as a very powerful reminder every day of the bloody conflicts that this country has been through, of our history of not holding everyone equal, of the fact that a large portion of our community did not have freedom, did not have liberty, were not allowed to have their own agency to live their own lives or their own, to go forth and be the agents of their own lives. And maybe if you don't, and I don't, have that background, maybe it's hard for us to understand how hurtful that might be. But I think it's not that hard to think about it, to think that if you're going out, if you live in Decatur or DeKalb, and we got a hub there with a lot of restaurants and cool things to do. People come from all over the state to that small, vibrant downtown. It's not that hard to imagine that if your people were the ones that was directed at 40 years ago to say, you aren't going to have equal justice under the law in this courthouse. And we are going to put this up to send a message that you were not free then, and you know what, you're not equal under the law now. It's not that much of a stretch for me to think that some other folks might say, I think I'd rather have something else in the middle of my community square. A couple other points that I want to make. It is, of course, already illegal to tamper with or destroy monuments. So to the underlying purpose of the bill, I don't know that it accomplishes much, considering that it is already illegal to deface monuments. So for my two amendments, let me explain them a little more. As I mentioned, DeKalb County, because they cannot find anyone to take the obelisk, is in the process of putting up a descriptive interpreter that gives a little more history about it. This legislation, unfortunately, goes further than just protecting monuments and providing additional penalties for those that might deface them. It unfortunately eliminates the opportunity that counties and other governments have had for 18 years to put up an interpretive marker. So it really takes us back and would eliminate the ability to do so. So amendment number 2 would preserve the ability of my community and your communities to have some agency over these monuments that are in the public space. Amendment number 3 is my bill, Senate Bill 53, and it would, if passed as a standalone, what it would do is it would allow local governments to remove or change these monuments, which is a power that they do not currently have. It would not mandate the removal of monuments. I agree with the Rules Chairman that there is historical value to monuments that were erected, 80 years ago, as this one was. It's not that there's no historical value. So it wouldn't require that they all come down, but it would allow local communities to make decisions about what they are going to honor and revere in the public spaces where they spend time. I'm not trying to tell Chickamauga what they have to have in the middle of their public square. So this would allow my community to decide what it can have in the middle of its public square. Now, the last thing I do want to say about number 3 is it would not undo, were it to be adopted here, it would not undo the Rules Chairman's bill. It would add to it the other enhanced penalties would stay that the Rules Chairman has presented, but it would allow local governments to, upon passage of a resolution, change the monuments and have more agency over them. So I ask for your support for amendments number 2 and 3. And I want to thank the Rules Chairman for the conversations that we've had. And one last thing before I answer any questions. I know a lot of people are spun up about how some of these monuments get defaced. But until you really think about what I said a few minutes ago, about how you might feel if this was a direct message to your community back then, and even now is still a reminder that your folks weren't free and that your folks weren't considered equal, until you really think about that, when you really think about that, you will understand why they get defaced. And until we're willing to have an honest conversation about that, they're going to continue being defaced. So I appreciate the opportunity to have this conversation. Mr. President, I'm happy to answer any questions.
You have no questions.
Thank you, Mr. President. I ask for your approval of amendments 2 and 3. I yield the floor.
This time I'd like to call upon the author of the bill, a senator from the 53rd, to close debate.
Thank you, Mr. President, and my colleagues. Thank you so much. I appreciate the camaraderie we've had behind the scenes with this bill. I'm going to talk about the amendments. Amendment 1, I'm definitely for that, with Senator from the 10th. Amendment 2, my olive branch to the senator from the DeKalb County. I'm okay with that. You vote your conscience. I can understand that. And by the way, they'd have the right to put that statue up right now, or the interpretive thing, if they wanted to. Number 3, with all due respect, that would change my bill that would no longer protect our monuments, so I would ask you to vote down number 3. Mr. President, I've appreciated the debate here, and I appreciate my colleagues listening to me, and I appreciate you voting for Amendment 1. I'm okay with 2. Vote down 3, and I appreciate you voting for the bill. Thank you very much. I yield the way.
Thank you, Senator. We will start by taking up amendment number 1. Amendment number 1. The question is on the adoption of the amendment number 1. Is there objection to the adoption of amendment number 1? Hearing none, the floor amendment is adopted. All right, now we'll take up amendment number 2. The question is now on the adoption of amendment number 2. Is there objection to adoption of amendment number 2? Hearing none, the floor amendment number 2 is adopted. The question is now on the adoption of amendment number 3. Is there objection to the adoption of amendment number 3? There's objection. All those in favor of the amendment from the senator from the 42nd will vote yea, oppose nay. The secretary will unlock the machine. On the adoption of the amendment, the yeas are 21, the nays are 33, and the amendment is lost. All right, the question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute is adopted as amended. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 34, the nays are 17. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, will you read the caption of Senate Bill 144?
Senate Bill 144 by Senator Anderson, the 24th, and others. A bill will be titled Enactment, Chapter 11, Title 48 of the OCGA, relating to taxes on tobacco products so as to provide for the issuance of special event tobacco permits to licensed dealers, authorizing off-premises sales of certain tobacco products at special events or temporary locations, to provide for such permits a fee and limitations as to the validity period and for other purposes. Mr. President, Senate Committee on Regulated Industries and Utilities offers the following substitute to Senate Bill 144. A bill be titled Enactment, Chapter 11, Title 48 of the OCGA, relating to taxes on tobacco products so as to provide for the issuance of special event tobacco permits to licensed dealers, authorizing off-premise sales of certain tobacco products at special events at temporary locations, provide for such permits a fee and limitations as to the validity period and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from Augusta to speak to Senate Bill 144.
Thank you, Mr. President. This is a very simple bill, dear senators. All this is where a business can get a temporary permit instead of having to get a permanent permit. At the time now, they have to get another permanent permit to do a temporary permit, and that's all it is. I yield I yield. If there's any questions,
You have no questions.
I ask you to vote green. Thank you.
Any other senator wish to speak for or against the measure? The question is now on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none, and the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill having received the requisite constitutional majority is therefore passed by substitute. Mr. Secretary, can you read the caption to Senate Bill 146?
Senate Bill 146 by Senator Gannon of the 47th and others. A bill will be titled enactment Title III of the OCGA relating to alcoholic beverages so as to provide that retail packaged liquor stores may conduct tasting events in which samples of alcoholic beverages may be served, to provide for definitions, to provide for terms and conditions of tasting events, to provide for the remission of taxes applicable to tasting events, and for other purposes. Mr. President, the Senate Committee on Regulated Industries and Utilities offers the following substitute to Senate Bill 146, a bill will be titled enactment Title III of the OCGA relating to alcoholic beverages so as to provide that retail packaged liquor stores may conduct tasting events at which samples of alcoholic beverages may be served, provide for definitions, provide for terms and conditions of tasting events, provide for notification of tasting events, and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 47th to speak to Senate Bill 146.
Good afternoon, ladies and gentlemen. I want to present to you Senate Bill 146. And I think I've only been down here 9 years, but I think this bill's been around for a long time. And I hope that we can get it passed today. I will tell you, my colleague from the 18th told me, he said, Senator, said this bill is not a milk bill, it's a liquor bill. And I said, yeah, you're right. Said we do more to regulate alcohol in this state than any place I know. Said this bill does simply one thing, and that's to allow for the tastings of alcohol, and simply the tasting of alcohol in a liquor package store. Said currently, that's not allowed. We do it in grocery stores. We can do it in a beer store, but we can't do it in a liquor store. What I want to try to do is make sure that everybody in here realizes I'm very respectful of our problem with people drinking and driving. So one of the things in this tasting, you'll notice that we only allow up to 52 tastings per year. Said that'd be an average of one a week. Said a tasting is only allowed for a 4-hour period, and at any time during the tasting, a store owner can only have up to 4 bottles of alcohol open. What's unique about this is when we look, we're not going to let you have a tastings for malt beverage one day, wine the same day, and liquor the same day. You can only have one type of alcohol in that tasting at any one particular time. So if your day is with malt beverage, said you could have up to 8 ounces is all you can have, the total of what an individual can be served. If we're talking about wine, it's a total of 5 ounces of wine served. If we're looking at distilled spirits, the only thing you can have is up to 1.5 ounces. So we don't want anybody leaving there under the influence of alcohol. This bill puts a reporting requirement in for the local government or the issuing authority to be notified of any tasting that would take place. Said it's a pretty simple bill. Said when we start to look at questions, I guess the easiest thing for me to do is yield, and if there's any questions, Mr. President, I'll take them at this time.
You have no questions.
Thank you, Mr. President. I yield the well.
Chair recognizes the senator from the 35th to speak to the bill.
Thank you, Mr. President. Senators, I stand to speak against Senate Bill 146. I have a problem with drinking on the premises of a liquor store. And I have a question about whether they would really stick to the limits, and I'll tell you why. Many years ago, I would sometime take my husband to work, and we owned a store that happened to be a liquor store. We owned it for 29 years. We didn't drink because people were sitting out there an hour before sometime to go in, to come into the store when it opened. And then when they got off work, they were back there again to buy liquor. People have problems. I don't think we should be allowing alcohol to be given on the premises. Another thing some of the liquor stores have started doing is selling ice by the cup. You're not supposed to drink. It's against most ordinances in many cities that you even drink anything on the premises or in the driveway of these liquor stores. So I owned with my husband up until he got sick a few years ago, and so for 5 years I have not had a liquor store. But I'm telling you, people will have trouble sticking to this 1 ounce. And what is that, 1 ounce for each bottle that's open? How many times are they gonna go out and come back in? These people are already intoxicated and they are needing alcohol. I say no, and I hope that you would look at the fact that they should not be drinking alcohol on the premises of, and follow the ordinances of most of the cities. Mr. President, I again ask for everyone's support on opposing this legislation. I do know that they allow tasting foods in grocery stores of what they're selling, but I don't think that alcohol should be tasted at the liquor store or the beer store. We had Skyline Liquor and we had R&E Package Store. And believe me, we had to hire a policeman not to have people on the premises. They could not even get out of the driveway before they were opening up a bottle. So if there are any questions, I'd be happy to answer them.
You have no questions.
Thank you. I yield the well.
Thank you, Senator. Does any other senator wish to speak for or against the bill? For what purpose does the senator recognize the senator from the 47th? Speak to the measure.
Thank you, Mr. President. Said they, plain and simple, guys, this is a legal product that's sold all throughout the states. Said there's about 1,200 alcohol liquor stores, package stores throughout Georgia. One of the things for me, the senator from the 35th, when I first came down here, we came in as both of being elected at the same time. We dealt with a very difficult issue, and that was Sunday's alcohol sales. Said they, for me, she shared with me in committee that her son was killed by a drunk driver. Said her and I both have experienced the loss of a loved one like that. Said I lost my son in an accident on our farm. For me, there's nothing that can replace that hole in your heart. Said this is one of the things that for me, alcohol is not the problem. It's the abuse and misuse of alcohol. It is a legal product. I do chair the Economic Development Committee in our Senate, and I'll ask for your favorable consideration on this bill. It's a legal product, and I need your help. Thank you.
Senator has yielded the well. Does any other senator wish to speak for or against the measure? This question is now on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 34, the nays are 18. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Will the secretary read the caption of Senate Bill 9?
Senate Bill 9 by Senator Jones the 22nd and others, a bill we titled and act amend Part 3 of Article 4 of Chapter 11, Title 16 of the OCGA, relating to invasion of privacy so as to prohibit sexual extortion, provide for definitions, provide for elements of the crime, to provide for penalties, to provide for venue, to amend Code Section 42.112 of the OCGA relating to the state sexual offender registry so as to provide a conforming cross-reference for other purposes. Mr. President, Senate Committee on Judiciary offers the following substitute to Senate Bill 9. A bill will be titled and act amend Part 3 of Article 3 of Chapter 11, Title 16 of the OCGA relating to invasion of privacy so as to prohibit sexual extortion, to provide for definition, to provide for elements of the crime, to provide for an exemption, to provide for penalties, to provide for venue, to provide for related matters, and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the Minority Whip to speak to Senate Bill 9.
Thank you, Mr. President. This bill is designed to try to fix a hole in the law that currently exists. So as you know, one of the things that we do is we have what's called revenge porn statute, which means if a person has received compromising photos of someone and they actually post those photos, that is covered currently by the law. What is not covered is where someone receives compromising photos or information, whatever it may be, and they threaten that person and say, if you do not send me sexually explicit photos of yourself, I would then post what I have, whatever that may be. And it can be pictures of sex. It could be things dealing with your economics. And so we don't have that covered. And this is actually just something that's kind of emerging. So actually in South Carolina, they had a, as they call it, a sextortion scandal. Over 200 soldiers were involved in it. Similar type process. Right here in Georgia, there was a federal case. What the person did in that federal case was, and this was a 2015 case, and what they did was they did a phishing scheme where they contacted the victims and said that they were part of Google and that basically they needed their password to kind of fix something on their computer. Unfortunately, many of those persons actually gave them the password. When they got the password, they then found compromising information on their computer. They then recontacted them and said, this is what I have. You see what I have access to your computer. If you do not send me more information, more compromising photos and things of that nature, I'm going to post this. And what happened is many of the victims actually went ahead and did that. But some actually said, I'm not going to send you anything. And of course, that person then went ahead and posted those photos. And this is the type of crime that obviously lasts for life. It's not anything that can possibly go away. So it's a whole. So we have the situation already covered. If you post photos, that is covered. But if you make the threat and threaten someone to try to get more information or get more photos, that is not covered. And so basically what we're doing is creating an attempted revenge porn statute. So it's going to be a new statute to kind of cover that. So it is something that is new, unfortunately, but it is growing, and it is something that we can protect our citizens to do. And I want to commend the Judiciary Committee and also the Senator 23rd, who helped a lot to try to get this bill hammered through. It took a lot because it's a new area to get this bill hammered through, and we were able to come up with one. Mr. President, I'd be glad to take any questions.
You have no questions.
Okay, thank you, Mr. President. I yield the well.
Does any other senator wish to speak for or against the measure? The question is now on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 55, the nays are 0. This bill having received the requisite constitutional majority is therefore passed by substitute. Mr. Secretary, please read the caption of Senate Bill 161.
Senate Bill 161 by Senator Tippins of the 37th and others. A bill will be titled enactment Title 20 of the OCGA relating to education so as to provide for weighted scores for certain coursework for purposes of determining Hope Scholarship and Zell Miller Scholarship eligibility and for other purposes. Mr. President, the Senate Committee on Higher Education offers the following substitute to Senate Bill 161. A bill will be titled enactment Title 20 of the OCGA relating to education so as to provide for weighted scores for certain coursework for purposes of determining Hope Scholarship and Zell Miller Scholarship eligibility and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize a senator from the 37th to speak to Senate Bill 161.
Thank you, Mr. President. Members of the Senate, I bring you Senate Bill 161. It's very brief in its content, but very meaningful in its outcome. Under current practice, those high school students who are taking advanced placement, international baccalaureate, or dual enrollment courses, those students who receive a B, a C, or a D in those courses receive an extra half point in the calculation of their composite score in the calculation for their eligibility of the Hope Scholarship and the Zell Miller Scholarship. Those students receiving an A do not get any extra credit. I think this was due in part to a false interpretation that there would be no grades given over a 4.0, which means that an individual, a student making a B in an AP course would get a 3.5, while a student getting an A only receives a 4.0. This bill very simply provides for those students who are receiving A's to get an additional half-point credit, just like those receiving B's, C's, and D's. I will submit to you that those students who are straight A students, this bill is not going to help because they're going to qualify anyway. But in the case of those students who may have strengths in one area and academic weaknesses in other areas, as in math or literacy being strong or weak, this will help tremendously in the calculation of their eligibility for Hope and Zell Miller. I urge you to vote in favor of this bill. It's a good bill. Mr. President, if there's no questions, I'll yield well.
You have no questions. Does any other senator wish to speak for or against the bill? The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none, and the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Moving on, Mr. Secretary, will you read the caption of Senate Bill 175?
Senate Bill 175 by Senator Black of the 8th and others, a bill be titled enactment Article 7 of Chapter 3 of Title 47 of the OCGA, relating to retirement allowances, disability benefits, and spouses benefits so as to require certain public employers to make employer and employee contributions to the teachers' retirement system of Georgia for employed beneficiaries and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 8th to speak to Senate Bill 175.
This little retirement bill is structured to shore up our teachers' retirement system. We're facing a serious challenge. We've got a $25 billion unfunded liability. Currently in the law, a teacher can retire and come back to work at 49% of her pay and continue to receive the retirement benefits. This is a real bonanza for the local school boards because they don't have to pay into the retirement system, nor do they have to pay on the insurance. This bill would require, in these situations, for the local board, when they hired these teachers and brought them back on, they would have to contribute to the retirement system, the employer and employee portion, and the employee doesn't accrue any additional service. It's still a financial advantage to the local boards because they're not having to pay the insurance, which the insurance is higher than the retirement. I'll entertain any questions anyone might have. Ask your favorable consideration.
Chair recognizes the senator from the 48th.
Thank you, Mr. President. Does the chairman yield?
Yes.
Could you please explain if this is going to hurt teachers who are coming back to help in retirement to those school systems that actually need these kind of teachers because there's not a lot of teachers available in that area?
This will not affect the teachers that won't come back. They'll still have that option. The only change it will make is these local boards will lose the advantage they have right now of getting them people at less expense than what it would be to hire a new teacher outright. But the same opportunity will be available to the teachers.
Thank you, sir.
Chair recognizes the senator from the 26th.
Thank you, Mr. President. To the gentleman in the wheel, do you yield?
I do.
Normally, they ask teachers in certain disciplines to come back if they can't find teachers in that discipline, or they've had a teacher that had to take leave if they were sick, and rather than have a part-time, get a certified teacher in that category. But the advantage to the boards of education was that they didn't have to pay any benefits package because that teacher had already retired, so the only thing they will be getting is a part of what they used to make on their salary. Now, will this eliminate those boards bringing those teachers back in those disciplines that they need in order to get help in certain situations?
This will not affect that.
But they would have to pay benefits for those
They'd
teachers.
have to pay benefit, but much of what you're describing, they can bring these teachers back and let them be substitute teachers or do it's less than a regular schedule.
Right.
And they would still be able to do that. But if they come back on, otherwise, and draw that 49%, then the local boards would have to contribute to the retirement system.
My question is, why would they contribute to the retirement system if the main reason they're bringing them back, they got a certified teacher that's in a discipline that they can hire to finish out that year full time and not have to pay that full salary?
That's exactly right.
But they're doing it now, but that's because they don't have to pay the other part of the retirement benefits. If they come back now, they're going to have to pay it.
They're doing it right now, and it's a big savings to the school board as compared to hiring another teacher that's not retired, because they don't have to make that contribution to the retirement system, nor do they have to pay the insurance. And remember, this insurance costs more than what the retirement does.
You have no more questions.
Thank you. Ask your favorable consideration.
Does any other senator wish to speak for or against the bill? The chair hears none, and the previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor will vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, can you please read us the caption of Senate Bill 176?
Senate Bill 176 by Senator Black of the 8th and others, a bill entitled Enactment, Chapter 2, Title 37 of the OCGA, relating to administration of mental health, developmental disabilities, addictive diseases, and other disability services, so as to remove a cross-reference to amend Chapter 2, Title 47 of the OCGA relating to the Employees' Retirement System of Georgia, so as to require certain public employers to make employer and employee contributions to the Employees' Retirement System of Georgia on behalf of retired members employed by such employers either directly or indirectly and for other purposes. Mr. President, Senate Committee on Retirement offers the following substitute to Senate Bill 176, a bill we titled enactment, Chapter 2, Title 37 of the OCGA relating to administration of mental health, developmental disabilities, addictive diseases, and other disability services, so as to revise a cross-reference to amend Chapter 2 of Title 47 of the OCGA relating to the Employees' Retirement System of Georgia, so as requires certain public employers to make employer and employee contributions to the Employees' Retirement System of Georgia on behalf of retired members employed by such employers either directly or indirectly and for other purposes. Mr. President, that concludes the order.
Chair would like to once again recognize the senator from Valdosta to speak to Senate Bill 176.
This bill right here is the twin to the one we just dealt with. This one deals with the employees' retirement system. Any questions?
That was quick. Quicker than I was ready. You have no questions.
Thank you.
Any other senators wish to speak for or against the bill? Chair hears none. The question is now on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, can you read for us the caption for Senate Bill 183?
Senate Bill 183 by Senator Huffstetler of the 52nd, a bill will be titled enactment in Chapter 2 of Title 48 of the OCGA relating to state administration and enforcement of revenue and taxation, so as to provide that each person that files or is required to file Form 1099-K with the Internal Revenue Service shall also electronically file a copy of each such form to the State Revenue Commissioner on or before the federal deadline and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 52nd to speak to Senate Bill 183.
Thank you, Mr. President. This bill is the last of the departmental bills from Department of Revenue and Commissioner Riley, and it simply asks that she be allowed to get the 1099-Ks when they go to the IRS, and there's just been a glitch in the law that doesn't allow it. Tennessee, Alabama, North Carolina, states like that are already getting it, and if there's no questions, I'll yield to well.
Chair recognizes the senator from the 27th.
Thank you, Mr. President. Mr. Chair, quick question. If you yield?
I yield.
Are 1099 miscellaneous and all their 1099s already covered? Is this just an addition to
This is just the addition. These are the third-party payments that haven't been covered.
So this is just a cleanup bill, essentially?
Correct.
Thank you.
You have no more questions.
Thank you, Mr. President. I yield to well.
Does any other senator wish to speak for or against the bill? The chair hears none, and the previous question is ordered. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is now ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 0. This bill having received the requisite constitutional majority is therefore passed. Mr. Secretary, moving on, will you read the caption of Senate Bill 184?
Senate Bill 184 by Senator Kirk of the 13th and others, a bill entitled Enactment Part 1 of Article 1 of Chapter 18 of Title 45 of the OCGA relating to the state employees' health insurance plan so as to provide that services covered under the state health benefit plan furnished by a federally qualified health center are reimbursed at no less than the Medicare maximum allowable reimbursement rate and for other purposes. Mr. President, Senate Committee on Health and Human Services offers the following substitute Senate Bill 184, a bill entitled Enactment Part 1 of Article 1 of Chapter 18 of Title 45 of the CGA relating to state employees' health insurance plan so as to provide that services covered under the state health benefit plan and furnished by a federally qualified health center are reimbursed at no less than the Medicare maximum allowable reimbursement rate and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 13th to speak to Senate Bill 184.
Thank you, Mr. President. Ladies and gentlemen, I bring you Senate Bill 184. What this does is expand access to health care by allowing participants in the state health benefit plan to go to federally qualified health centers and use them as a primary care physician. Those federally qualified health centers are located throughout the state, even here in Metro Atlanta. So this would be a good access to health care, and it also will reimburse them at the Medicare rate. So if there are any questions, I'll be happy to take them, but otherwise I ask for your favorable consideration for this bill.
Chair recognizes the senator from the 52nd.
Thank you, Mr. President. Would the senator yield?
Certainly.
You know, earlier in this session, we passed the direct primary care, the Medicaid waivers, and these are supposed to increase access to primary care. So would you say this is an additional bill that will increase primary care to the citizens of Georgia?
Yes, Senator, I certainly do.
Thank you, Senator.
Thank you.
The chair recognizes the senator from the 38th for a question.
Thank you, Mr. President. Will the senator yield?
Certainly.
Can you give me an example of what a federal health center is?
A federally qualified
Okay.
health center?
Yes, okay.
They're located throughout the states,
Right.
and they actually have get a case a higher rate of reimbursement because they have wraparound services. So when a person goes to those centers, they get case management, and they look at transportation and other needs that they may have. And the good thing about this is we talk about access to health care. If you choose a federally qualified health center for your primary care doctor, then you have access to all the benefits that they may offer. And some of them offer mental health services and so forth.
Thank you.
You're welcome. Thank you.
You have no more questions.
Thank you. I ask for your favorable consideration.
Does any other senator wish to speak for or against the bill? Hearing none, the question is now on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none, and the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The Secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, please read for us Senate Bill 188.
Senate Bill 188 by Senator Walker, the 20th, and others, a bill be titled enactment code section 33714 of the OCGA relating to reinsurance of risks so as to provide adequate regulation of reinsurers, to provide for the incorporation of the National Association of Insurance Commissioners reinsurance model law into the Georgia Insurance Code to provide domestic ceding insurers credit as either an asset or deduction liability on account of reinsurance purchase only when the purchase meets new requirements and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 20th to speak to Senate Bill 188.
Thank you, Mr. President. Good afternoon again, colleagues. This is another insurance update bill. Georgia has a National Association of Insurance Commissioners accreditation, and in order to maintain that accreditation, we have to adopt NAIC model legislation to stay in compliance. That's what this bill does. It has to do with credit for reinsurance. So an insurance company lays off part of their risk or cedes part of their risk by buying reinsurance from another insurance company. And this is language related to that, and an insurance company gets credit for that reinsurance on their balance sheet. It's kind of a technical bill. If you have any questions, I'll try to answer it. Otherwise, I ask for favorable consideration.
You have no questions, Senator.
Thank you. I yield the will.
Does any other senator wish to speak for or against the measure? The chair hears none, and the previous question is now ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. Hey. On the passage of the bill, the yeas are 52, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, will you read the caption to Senate Bill 109?
Senate Bill 109 by Senator Walker, the 20th, and others, a bill be titled enactment code section 433425 of the OCGA relating to delegation of certain medical acts to advanced practice registered nurses so as to authorize the delegation by physician to an advanced practice registered nurse to order radiographic imaging tests in non-life-threatening situations, to revise the definition, to increase the number of advanced practice registered nurses with whom a delegating physician can enter into a nurse protocol agreement, and for other purposes. Mr. President, Senate Committee on Health and Human Services offers the following substitute Senate Bill 109, a bill to be titled Enactment Code Section 433425 of the OCGA, relating to delegation of certain medical acts to advanced practice registered nurse so as to authorize the delegation by physician to an advanced practice registered nurse who has been licensed for at least 5 years to order radiographic imaging tests in non-life-threatening situations and for other purposes. Mr. President, that concludes the order.
For what purpose does the senator from the 20th rise?
Mr. President, I ask for unanimous consent to table Senate Bill 109.
Senator from the 20th has asked for unanimous consent to table Senate Bill 109. Will the Secretary read the caption? Oh, you just read the caption. I wasn't paying attention. Sorry about that. Any objection to tabling Senate Bill 109? There's no objection. And Senate Bill 109 is placed on the table. Mr. Secretary, will you read the caption to Senate Bill 192? Moving on.
Senate Bill 192 by Senator Jones of the 25th, a bill to be titled Enactment Title 33 of the OCGA relating to insurance so as to extensively revise Chapter 41 relating to captive insurance companies, provide for definitions, provide for the use of a registered agent to receive service of process, provide for sponsored captive insurance companies, to provide for letters of credit, provide for filings and notifications to the Commissioner, and for other purposes. Amendment 1 by Senator Jones of the 25th and others offers the following amendment. Amend Senate Bill 192 by striking line 256 and inserting in lieu thereof protected cells by striking lines 257 through 281. Mr. President, that concludes the order.
For what purpose does the senator from the 25th rise?
Mr. President, I move that Senate Bill 192 be tabled.
Senator from the 25th has moved that Senate Bill 192 be tabled. Is there objection? Hearing no objection, Senate Bill 192 is on the table. Mr. Secretary, will you read the caption to Senate Bill 202?
Senate Bill 202 by Senator Ligon III and others, a bill to be titled Enactment Code Section 3378 of the OCGA relating to title insurance so as to allow title insurance to be procured on a lender's security interest in personal property taken by the lender as collateral for a commercial loan and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 3rd to speak to Senate Bill 202.
Senate Bill 202 allows title insurance companies to also insure title to personal properties such as inventory, equipment. We're seeing this as a need in large transactions where a lender may be lending a company money to expand a manufacturing plant or something else, and the lender wants to insure the title to that personal property. And we're talking of loans that may be $50, $100 million. So unless there are any questions, Mr. President, I'll yield the well.
You have no questions. Does any other senator wish to speak for or against the bill? The chair hears none, and the previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. The Secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, will you read the caption to Senate Bill 208?
Senate Bill 208 by Senator Robertson of the 29th and others, a bill entitled an act to amend Article 3 of Chapter 5 of Title 40 of the OCGA relating to cancellation, suspension, or revocation of licenses, so to revise the implied consent notices and for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 29th to speak to Senate Bill 208.
Thank you, Mr. President. My fellow senators, Senate Bill 208 is a response to the Georgia Supreme Court recent decision, which took the Georgia implied consent and moved the compulsion for breath out of the implied consent. The implied consent is what's given to a person who's suspected of driving a vehicle under the influence in Georgia. So the Georgia Supreme Court, in their opinion, concluded that the asking for breath was compelling an individual to give evidence against himself under the threat of losing their driver's license. So they took that out so that the Georgia implied consent would only apply to blood and urine, of which I've never known anybody to ask for urine. And so that all it would do is when the individual was stopped, they would be given the option of giving blood or urine. They would have the right to refusal. If they chose to give the blood, they would be transported and the sample would be taken. And if they refused all, then that would be included in the officer's report that they did refuse. And I ask that you vote yes on this. And Mr. President, I yield the well if there are no questions.
The chair recognizes the senator from the 46th.
Thank you, Mr. President. Will the senator yield?
Yes, sir.
My concerns are with the language on lines 33 and 34 of the implied consent warning that you propose. This would be the new warning, where it says your refusal to submit to blood or urine testing may be offered into evidence against you at trial. And the reason for this bill that you brought forward was the Georgia Supreme Court case of Elliott versus the state that was decided just this February, just a few weeks ago. And they were very clear in that opinion that even though it didn't address the specific issue of threatening somebody that you would use their refusal against them at trial, that where the state first threatened that you would introduce it into evidence and the person refused, it would be evidence against them at trial. The indication is that that would be unconstitutional as well. So I hate for us to replace an unconstitutional implied consent warning with another unconstitutional implied consent warning. Have you contemplated that aspect of it?
Yes, sir. And the ruling, as I read through it from the Georgia Supreme Court, and again, based on my experience, the concern that the Georgia Supreme Court showed was the compelment of the breath, that the individual would have to stand there and blow into the intox, where they're given 3 opportunities. And we're not talking about the Alka-Sensor on the side of the road, but we're actually talking about the intox that's inside the jail, where the trained expert is taking the deep lung air and measuring the BAC in that. And they said that by having them go in there and do that, put that effort out, and when the issue of blood came up, they did not see that reach up to the same level as compelling as the individual then. If they were taken to the hospital to draw the blood, they would just have to stand there. They would not have to supply the blood themselves, that a trained professional would take it. And that was the primary concern for the court ruling blood was unconstitutional, which was the only part of the implied consent that they declared unconstitutional, was because of the effort being put out by the individual.
I understand that, but in their language of the decision, they made it clear that if this factual scenario came before them, that it would be tenuous at best. So I just wanted to make sure we were on the same page with that.
Yes, sir. Thank you, Senator. I believe so. And the main goal of this is to stabilize the implied consent until after there's an opportunity to sit down, and even to the point of possibly an amendment to correct the issue in the Constitution that caused the breath to be found unconstitutional to begin with. Other states around us use the exact same test, but their Constitution reads a little different when it comes to self-incrimination.
You have no more questions.
Thank you, Mr. President. I yield the well.
Chair recognizes the senator from the 35th to speak to the measure.
Thank you, Mr. President. I would have to reluctantly stand for this legislation. And I say reluctantly because I'm a Mothers Against Drunk Driving member and advocate, and we are all devastated over the decision that was made by the state Supreme Court about a week and a half ago, that they are really supporting those who are driving under the influence, especially habitual drunk drivers, because now they can refuse, according to the court ruling, blood or urine tests as well as the breathalyzer. So this legislation would be like many other states, and it will give a temporary fix. I hope that we can come back and somehow study this whole thing, and that we can get the state Supreme Court to change their decision somehow, or we can do something, because many years ago, as you heard from the senator from the 47th, we both lost loved ones. And my loved one was my teenage son, who had gone to the store for one of my neighbors, just trying to help someone, when a 5-time DUI offender in an 18-wheeler with a temporary license took his life, rammed into him and took his life. He refused to take the breathalyzer or the blood test, but beer cans fell all out of the cab of his truck, of his vehicle, when the police pulled him out. And as a result, the law still supported him and allowed this man to not be able to use the evidence, because the police took him anyway to Grady Hospital, and his blood level was 3 times over the limit. But they allowed it anyway. And then I found out, after Mothers Against Drunk Drivers was helping me and my family as we were going through the court system after losing my child to that drunk driver, we found out that we were among many, so many in Georgia, whose loved one was killed by a habitual drunk driver. So when this legislation came, we found out that someone had changed it where if you refuse to take these tests, that you would be considered guilty. We were elated and we rejoiced over it, because we felt that that would at least stop habitual drunk drivers. And so now the decision has really torn that completely apart. But again, this legislation will at least allow some of those who are in that category be able to, you can get I guess, what is it? You can, if you get your blood tested, that's not taking your breath. That is, you can get what is it, Harold? I forgot. Anyway, you can be able to do this. So I hate to get up here and hoo and ha, but I just want to tell you that we have to do something to change, and I see a necessity to do more measures. The interlock, something we have to do. So as we're looking at this issue, please vote yes today so we can at least have a temporary fix. But let us look at it closer so that we can at least have an interlock or something that could identify habitual drunk drivers. I just will take any questions. If not, I yield the will, Mr. President.
You have no questions.
Thank you.
Does any other senator wish to speak for or against the bill? The chair hears none, and the previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 46, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, will you read our final bill of the day, House Resolution 182?
House Resolution 182 by Representative Green of the 151st and others. A resolution authorizing the granting of non-exclusive easements for the construction, operation, and maintenance of facilities, utilities, roads, and egress in, on, over, under, upon, across, or through property owned by the state of Georgia and Barrow, Camden, and other counties, and for other purposes. Mr. President, the Senate Committee on State Institutions and Property offers the following substitute to House Resolution 182. A resolution authorizing the granting of non-exclusive easements for the construction, installation, operation, maintenance of facilities, utilities, roads, and ingress in, on, over, under, upon, across, or through property owned by the state of Georgia and Barrow, Camden, Cobb, and other counties, and for other purposes. Mr. President, that concludes the order.
I'd like to recognize the senator from the 15th to speak to House Resolution 182. It's only the last measure of the day.
Thank you, Mr. President. Excuse me. That's what I get for eating M&Ms in the back. This bill, members of the Senate, if you please, is simply a housekeeping bill dealing with conveyance of property by our commission in Cobb, Floyd, Forsyth, Howell, Houston, Jeff Davis, Montgomery, Poland, Barrow County, Camden, and White counties. And it provides for related matters to provide for an effective date to repeal conflicting laws and other purposes. And the people whose counties are involved have been already notified about this, and I'm sorry, I'm out of breath. But the state of Georgia is owner of the certain real property involved in those counties that I mentioned earlier. And it is this housekeeping bill for the commission this year. And I urge it to you, provide it to you for your perusal and approval if you so desire. Appreciate it.
You have no questions.
Thank you, Mr. President.
Any other senator wish to speak to or for or against the measure? The question is now on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the adoption of the resolution by substitute? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this resolution now be adopted? The question is on the adoption of the resolution by substitute. All those in favor of the resolution will vote yea. Opposed, nay. The Secretary will unlock the machine. On the adoption of the resolution, the yeas are 53, the nays are 0. The resolution, having received the requisite constitutional majority, is therefore adopted by substitute. For what purpose does the majority leader rise?
Mr. President, I move that the Senate stand adjourned until 10 o'clock